Concerns or objections? Okay. Moved by Jean Neville, seconded by John Agate. Be it resolved that the Committee of Adjustment hereby appoints Honoree Tall as chair for the November 24th, 2025 meeting. All those in favor? Okay, that's carried. All right, and I'll now pass it over to our chair, Honoree Tall.
Of course, thank you. I'll say again, good morning, and I welcome everyone to the meeting. So we did call it to order at 9:31. Today's proceedings are being held as a hybrid meeting by way of in-person attendance and teleconference to hear minor variance applications PLMB 2025-085 and PLMB 2025-093. The Committee of Adjustment is appointed by Council to consider applications for minor variances to the zoning bylaw pursuant to Section 45 of the Planning Act. A minor variance may be granted provided it meets the four tests, namely that the variances meet the general intent of the official plan and zoning bylaw, that it is minor in nature, and that it is desirable for the appropriate development or use of the land, building, or structure. The Planning Act requires that a public hearing be held. The public hearing serves two purposes. First, to present to the Committee of Adjustment and public the details to the application, and second, to receive comments from the public and agencies before a decision is made. All submissions form part of the public record. Both the Secretary Treasurer and myself will be responsible to ensure that all parties and the committee members can hear one another during the hearing. For those attending by teleconference, if any time you're having difficulties hearing what is being said, please say so or click the raise hand button or dial *9. We kindly ask that everyone speak slowly and clearly when addressing the committee. If you're of the opinion that holding the hearing as an electronic hearing is likely to cause significant prejudice, we ask that you advise this committee at the earliest opportunity and the matter can be addressed accordingly. Any applicant or agent that is in attendance at today's meeting for a specific application may leave the meeting once the application has been considered by the committee. Any applicant, agent, or member of the public wishing to address the committee for a specific application is reminded that presentations are limited to 10 minutes per person. If you are using a computer or electronic device, please ensure that your microphone is turned on and your audio settings are not muted. All parties will be verbally acknowledged before being asked to proceed. At this time, I will ask that anyone who objects to an electronic hearing of a matter on today's agenda or is having difficulty hearing what is being said, please click the raise hand button or dial *9. No one? We'll proceed. The committee will first adopt the agenda. Would the Secretary Treasurer please read the resolution?
Moved by Paul Radals and seconded by Jean Neville. Be it resolved that the Committee of Adjustment hereby approves the agenda of the November 24th, 2025 meeting as circulated.
All those in favor? That's carried. Thank you. Do any committee members have a pecuniary interest in the application being heard today? No? There are minutes to approve from the October 27, 2025 meeting. Does the committee have any comments or questions? None? Thank you. Would the Secretary Treasurer please read the resolution?
Through you, Madam Chair, just to confirm, I did change the resolution to say as amended, as I did make those corrections to spelling in some of the spots that were missed previously. Moved by Paul Radal, seconded by Jean Neville. Be it resolved that the Committee of Adjustment hereby approves the meeting minutes of October 27th, 2025 meeting as amended.
All those in favor? It's carried. Thank you. I now declare this to be a public hearing for application PLMV 2025-085, located in part Lot 19, Concession 7, Geographic Township of Lutterworth. Would the planner please summarize the proposed variance and any correspondence received to date regarding this application?
Good morning. Through you, Madam Chair, application PLMV 2025-085 was submitted by Summer Suite Custom Design and Build, Inc. on behalf of property owners Dave O'Hara and Jeanette Wing for the property known municipally as 1014 Orchid Lane. As provided in the application, the property is developed with a single detached dwelling and attached covered porch and open deck. A small storage shed is also located on the property. The property owners want to construct a two-story garage having a ground floor area of 77.3 square meters or 832 square feet. The main floor of the garage will provide for vehicle parking and a small storage room. A 66.9 square meter or 720 square foot area on the second floor of the building is proposed to be used for storage only. The proposed two-story garage will be located 50.1 meters or 164.3 feet from the shoreline of Gull Lake and is proposed to have a height of 5.56 meters or 18.24 feet. The application requires the following relief for the township zoning bylaw. From section 5.2 to permit the reduced setback of 10.05 meters or 33 feet for a two-story detached garage to the rear lot line, whereas otherwise a setback of 12 meters or 39.4 feet is required. From section 4.9.1 to permit development on an existing undersized lot where additional relief from the zoning bylaw is required. The application is subject to the 4 tests of minor variance as outlined by the Planning Act, being that it must be minor in nature, desirable for the appropriate development of the land, conform to the general intent, and uphold the general intent of the zoning bylaw. Test number 1 is the application minor in nature. When assessing whether an application is minor, the consideration must relate to the potential impacts of the variance requested. The property maintains mature tree lines along the side and rear yards, except where the existing entrances and driveways are located. There's a significant incline in elevation from the shoreline to the rear of the property, providing visual buffers from both the lake and neighboring properties. Additionally, the rear lot line is adjacent to a private road, being Orchid Lane. In addition to the fact that Orchid Lane is largely traveled by only a few seasonal property owners, the proposed garage will exceed the minimum setback to a private easement and traffic impacts are not anticipated. The application is therefore found to be minor in nature. Test number 2, is the application desirable for the appropriate development or use of the land, building, or structure? A garage is permitted on the property and the proposed use is consistent with development in the surrounding area. As identified and observed on site, there are no alternative locations on the property that would be able to accommodate the garage without either imposing on the neighboring property or the dwelling. Opportunities to meet the setback is further challenged by the presence of rock outcrops, which would require significant site alteration to accommodate the 12-meter setback to the rear lot line. The garage will be located well outside of the required water yard setback. And a site visit conducted by township staff on September 17th, 2025 confirmed that the area for the proposed garage required minimal tree removal. The application is found to be desirable for the appropriate development or use of the land, building, or structure. Test 3, does the application uphold the general intent and purpose of the official plan? The subject property is designated waterfront on Schedule A of the township's official plan, and the property is located within 300 meters of a moderately sensitive lake. Properties adjacent to moderately sensitive lakes retain existing development rights. As the development will be located well outside of the 30-meter required water yard setback from the lake, no impacts as they relate to lake sensitivity are anticipated. Additionally, the garage will be farther from the shoreline than the existing dwelling and no impacts to the balance of built natural form within the shoreline is expected. The application is considered to uphold the general direction and purpose of the official plan. Test 4, does the application uphold the general intent and purpose of the zoning bylaw? The subject property is zoned shoreline residential on Schedule 13 of the Township zoning bylaw. Accessory buildings, including garages, are permitted uses on the property. The original design of the building included a patio door and upper floor balcony, all of which are considered accessory to residential use and would require review under provisions of a sleeping cabin. Through discussion with the applicant, it was confirmed that the intention for the second story was to be left as an unfinished storage area. Therefore, revisions to the building's design will be implemented to remove the patio door and the upper story balcony. Any future change in the use to a sleeping cabin would require planning approvals and significant renovations to comply with the zoning bylaw. Although the rear lot line is adjacent to a private road, the proposed setback of the building will achieve 3 times the minimum setback required as per the zoning bylaw. And as a result, the garage would not have any adverse impact on the visual integrity or the use of the road. The garage will also continue to meet the minimum 1.5 meter separation distance to the primary dwelling. Save and except the rear yard setback, all other development standards would comply with the township zoning bylaw. And the application is considered to uphold general intent and purpose of the zoning bylaw. I would like to note that a building permit was previously issued for this property. The original garage location complied with the township zoning bylaw regulations. However, during the land preparation for construction, it was discovered that due to the presence of rock outcrops, a slight change in the location of the garage was required. And as a result, the setback could no longer be met. And planning approvals were identified at that time to be required. The application is also required to be consistent with the provincial planning statement, PPS. Under the policies of the PPS, the subject property is considered rural lands. Permitted uses on rural lands include resource-based recreational uses, such as recreational dwellings and associated accessory uses that maintain the rural character and can be sustained by rural service levels. The application does not conflict with policies of the PPS. Notice of this application was circulated to neighboring owners and commenting agencies in accordance with the statutory requirements of the Planning Act on November 13th, 2025. A signed notice was also posted at the property. As of the date of the report, no comments from agencies or the public had been received, and to date, the application appears to meet the 4 tests of the minor variance and is consistent with policies of the PPS. Therefore, it is recommended that application PLMV 2025085 be approved, subject to the conditions outlined in the report.
Thank you. Is the applicant or property owner here today?
I believe they're attending virtually.
To virtual?
They're attending by phone.
So are we connected with the teleconference? Please state your name for the record and provide any additional information you would like to present to the committee. Are we connected? I'm sorry. Yes. Looks like we are on teleconference. Please state your name for the record and provide any additional information you would like to present to the committee.
Jane, can you hear us? Jane, can you hear us? perhaps we can move on, and if she is able to connect, then we can circle back around.
We're going to return back to this application. We'll move to the next.
No, we'll continue through the process,
Okay.
and if she's able to connect, then we'll pause for that.
So are there any members of the public who would like to speak to this application? We will start with anyone attending electronically. That's not-
Is there anyone else, Donna?
Anyone here on the
Okay.
floor?
No, nobody virtually.
Well, there's no one attending in person, no one electronically. So are there any questions or comments from the committee to the application, the planner, or any persons who have made presentations? Committee, yes, please.
Thank you, Madam Chair. Just some questions for the planner. Under section 4.1.13, which is the sleeping cabin, my understanding of the bylaw was that if you had a second floor on a garage, it was mandatorily set to be a sleeping cabin. I've experienced having a couple of building permits that even though the landowners were saying it was going to be storage, they still had to comply with having to make it as if it was a sleeping cabin, and even had to adjust the septic system. Can you help me understand why this application doesn't have those requirements?
Through you, Madam Chair. I wouldn't be able to speak for any prior, but certainly can speak to the application. It was identified through discussions that the upper floor will be an unfinished area. The bylaw, and specifically in 4.1.13, does not technically specify that the upper level is required to be a sleeping cabin. In this case, the proposed use and design identifies that it would not be standard to be used for habitable space.
And there is no plumbing going to the garage?
No.
Thank you.
Are there any further questions or comments from the committee? Or to the applicant, the planner, or any other persons who have made presentations? Comments may also be reasons why the application may or may not be supportable for the purposes of a decision. Any discussion further? As there are no further comments,
Sorry, Honor, I think
I'm sorry.
Committee Member Neville was going to say something.
I was just going to mention, like in support of the application, that the building permit was already issued for this, and it seems a logical step that we pass this because it had to be adjusted due to the rock. So I think that is a valid reason to accept this minor variance.
So it's a matter of setback, question of setback.
Correct.
Yes, thank you. As there are no further comments, would the Secretary Treasurer please read the proposed conditions for the minor variance?
Through you, Madam Chair. So the first is that, let me just make sure I have the right report before I read them. So the first is that approval of the minor variance is only in relation to this two-story garage with a specifically unfinished second story for storage only, and that it would comply with all applicable law. That construction would proceed in accordance with the plans that were put that were submitted to the township and then put towards the committee today. The third being that Ontario Land Surveyor confirmed the setback requirement to the satisfaction of the township. Fourth being that the building permit, which is to remain in good standing, be revised as required within 6 months of approval of this application, including anything required by the chief building official. And the last being that failing any part of the foregoing conditions, the application would be refused.
Are there questions or comments from the committee regarding these conditions? None? Thank you. Hearing all the evidence before, is the committee ready to make a decision? Would the Secretary Treasurer please read the resolution?
Through Madam Chair, I will read. I just want to check in whether or not we were able to connect with anyone online that wanted to speak in favor of their position. Okay, nobody. Okay, let me just finish writing the reasons out and I will read it out.
So are we ready to take a vote?
I just have to I'll finish writing out the rationale as provided
you.
by Jean Neville, and then I will I'll read out the resolution for voting. Okay, moved by John Aggett, seconded by Jean Neville, whereas the Committee of Adjustment considered the written and oral submissions relating to application PLNV 2025-085 O'Hara and Wing made at the hearing. And whereas it is the opinion of the committee that the relief granted maintains the general intent of the official plan and zoning bylaw, is appropriate and desirable for the area and is minor in nature, and more specifically for the following reason, that the building permit was already issued and the garage location needed to be adapted due to the rock outcrops. Now therefore it is the decision of the committee that the application PLNV 2025-085 requesting relief from the requirements of bylaw 06-10 as amended to permit the following: from section 5.2 to permit a reduced setback of 10.05 meters or 33 feet for a two-story detached garage to the rear lot line, whereas otherwise a setback of 12 meters or 39.4 feet is required. And from section 4.9.1 to permit development on an existing undersized lot where additional relief from zoning bylaw is required, both to be approved, subject to the following conditions. That approval of the minor variance shall only relate to the proposed new 77.3 square meter or 832 square foot two-story garage with a 67 square meter or 720 square foot unfinished second story to be used for storage only, construction of which shall comply with all other applicable law. That construction shall proceed substantially in accordance with the site and building plan submitted to the township on October 16th, 2025, revised on November 7th, 2025, and put before the committee on November 24th, 2025, and forming part of this decision. That an Ontario Land Surveyor shall confirm the setbacks in accordance with the approved site plan to the satisfaction of the township. That the building permit, which is to remain in good standing, be revised within 6 months of approval of this application, following submission to the building department of the appropriate application, fees, and supporting information as required by the chief building official. And that failing any part of the foregoing conditions, this application shall be deemed to be refused.
All those in favor? That's carried. Thank you. Would the Secretary Treasurer please advise the applicant and the public of the next steps?
Yes, Madam Chair, through you, having approved application PLNV 2025-085, there will be a notice of the decision sent out within the next 10 days. And the decision will also identify a 20-day appeal period. In order to be kept advised of an Ontario Land Tribunal hearing or to receive a copy of the hearing or of the decision, public must request a copy to the planning department.
So I now declare this matter to be concluded. I now declare this to be a public hearing for application PLNV 2025-093, located in part Lot 33, Concession 4, Geographic Township of Snowden. Would the planner please summarize the proposed variance and any correspondence received to date regarding this application.
Yes, thank you, Madam Chair. This will be my round two, so hopefully I had my fumbles out in my first through the chair to the committee. The application was submitted by Andrea Cowan Molyneux on behalf of property owners Blair and Jocelyn Cowan for the property located in Part Lot 33, Concession 4, Geographic Township of Snowden, known municipally as 1085 Lucky Copper Trail. As per the application, the property is approximately 0.3 acres with an approximate shoreline frontage of 30.5 meters or 100 feet on Salerno Lake. The property was originally developed with a single detached dwelling, a sleeping cabin, a woodshed, and 2 frame sheds were also located on the property. As originally developed, the lot coverage exceeded the maximum 15% permitted. The property has been approved for the demolition and redevelopment of a 115.18 square meter or 1,240 square foot dwelling, together with an attached portico and an attached covered deck, which is currently underway. The owners wish to also construct a 1-story 52 square meter or 559.6 square foot garage. Construction of the garage would exceed both total lot and accessory building structure lot coverage. Upon the original minor variance application submission and review, staff determined that the proposed minor variance would be difficult to support, and options were discussed with the applicant. It was identified based on the information provided that purchasing a municipally owned shore road allowance that lies in front of the subject property would increase the lot area to bring the development into compliance with the township zoning bylaw. It is important to note that the property owners have since applied to purchase the SRA, and therefore the minor variance would only be necessary to provide temporary relief from the zoning bylaw until the SRA lands have formally been acquired. The application requires the following relief from the township zoning bylaw. From section 5.2 to permit a 19.6 total lot coverage, whereas otherwise a maximum of 15% is permitted. From section 4.1.8 to permit a 6.8% accessory building and structure lot coverage, whereas otherwise a maximum of 5% is permitted. From section 4.9.1 to permit the development on an existing undersized lot where additional relief from the zoning bylaw is required. The application is subject to the 4 tests of a minor variance as outlined by the Planning Act. Test number 1 is the application minor in nature. When assessing whether an application is minor, the consideration must relate to the potential impacts of the variance requested. In addition to mature tree lines along the east and rear lot lines, pockets of vegetation are scattered along the west property line as well, and provides visual buffering to neighboring properties. The property is relatively flat and therefore does not require significant site alteration to accommodate the garage at the rear of the property. The location of the building will be set back farther from the lake and behind the dwelling, and therefore the exceedance in lot coverage will have no visual impact to the waterway or on the waterway. The application is therefore found to be minor in nature. Test 2 is the application desirable for the appropriate development of the use of the land, building, or structure. The garage is permitted on the property and the proposed use is consistent with the development in the surrounding area. The surrounding area consists of various lot sizes with single detached dwellings and accessory structures. Despite the lot coverage exceedance, the development is compatible with the existing physical character of the neighborhood. Although the lot coverage will exceed permitted maximums, significant tree removal or site alteration is not anticipated, as I said before, to accommodate the construction of the garage. The application is found to be desirable for the appropriate development or use of the land, building, or structure. Test 3, does the application uphold the general intent and purpose of the official plan? The subject property is designated waterfront on Schedule A to the township's official plan. Permitted uses in the waterfront designation include recreation-based residential uses in the form of single detached dwellings. The official plan states that the development of existing undersized lots may be permitted, provided that it can be demonstrated that the lot is suitable for development and the intent of the official plan is maintained. Circumstances may occur where reduced requirements are appropriate. Typically, this happens where there's an opportunity to compensate for the deficiencies. The subject property is significantly deficient in both lot frontage and area, which does not provide many opportunities for compensation. Further to this, the lot as existing does not meet the current minimum development standards of a buildable lot and has not been addressed through site-specific zoning as directed in official plan policy. Although the existing development on the lot is recognized, the proposed development and increased lot coverage does not uphold the general intent of and purpose of the official plan on its own. With that being said, official plan policy does suggest that where possible, lands should be merged to create larger parcels. There's as noted before, there's a township-owned SRA that lies in front of the subject property, and acquiring these lands, as per the application, the information in the application, these lands will provide an approximate 49% increase in lot size. Therefore, it's deemed appropriate that the planning review consider the additional SRA lands while assessing the appropriateness and supportability of this amended application. The application will provide for an interim solution until the SRA purchase is finalized. Purchase of the SRA will also ensure that the balance of built and natural form is maintained for the overall property. Based on the foregoing, excuse me, apparently my fumbles were not gone. It is the opinion of staff that the application is considered to uphold the general direction and purpose of the official plan, providing the SRA lands are purchased. Test number 4, does the application uphold the general intent and purpose of the zoning bylaw? The subject property is zoned shoreline residential on schedule. In the township zoning bylaw, a garage is a permitted use accessory to the primary dwelling. A single-story garage is permitted in any required interior side or rear yard, provided that an SR zone property, it is no closer to the side or rear lot lines than 2 meters or 6.6 feet. As proposed, the setbacks would be in excess of 4.5 meters for both the side and the rear lot lines. The proposed total lot coverage on the property with the existing lot area of 0.3 acres would be increased to 19.6%. The proposed garage would also increase the accessory coverage to 6.8%, whereas a maximum of 5% is permitted. Lot coverage provisions ensure the appropriate scale of development is achieved and also help to prevent overdevelopment, which can result in negative impacts considering stormwater runoff and compatibility with the surrounding lands. The application does not appear to uphold the general intent of the zoning bylaw on its own, as the proposal to increase the lot coverage to this extent would be considered as an overdevelopment of the property. However, as the owners have already applied to purchase the SRA lands, it is suitable to consider the increased total lot area that would result from the purchase. Given that the lot area will increase from 1,227 square meters or 0.3 acres to 1,840 square meters, 0.45 acres. It's expected that the property will come into full compliance with the zoning bylaw upon completion of the purchase of the SRA lands. Save and accept lot coverage, all other provisions of the SR zone can be met and are met. As reviewed, the current application would provide temporary relief from the zoning bylaw. Once the purchase of the Shore Road allowance is finalized, the expected total lot coverage would be 13% with an accessory lot coverage being 5%. The lot coverage would then comply with the township zoning bylaw. It is important to note that given the expectation of compliance with the township zoning bylaw as a result of the purchase of the Shore Road allowance, the building department has issued a conditional building permit for the proposed garage, recognizing the longevity of the process of purchasing a Shore Road allowance. the conditional permit will allow construction to commence sooner and also simultaneously with the dwelling reconstruction. So it would reduce the cost to the landowners and also reduce the disturbance to the neighboring property owners. The application is also required to be consistent with the provincial planning statement of the PPS. Under the policies of the PPS, the subject property is considered rural lands. Permitted uses on rural lands include resource-based recreational uses such as recreational dwellings and associated accessory uses that maintain the rural character and can be sustained by rural service levels. The application does not conflict with policies of the PPS. Notice of this application was circulated to neighboring owners and commenting agencies in accordance with statutory requirements of the Planning Act on November 13th, 2025, and a sign was also posted at the property. As of the date of writing this report and today, no comments on the application have been received by members of the public or agencies. And the application appears to meet the 4 tests of a minor variance and is consistent with the policies of the PPS. Therefore, it's recommended that application PLMV 2025-093 be approved, subject to the conditions outlined in the report.
Thank you. Thank you. Is the applicant or property owner here today? Please approach the table. Good. Please state your name for the record and provide any additional information you would like to present to the committee.
Thank you, Madam Chair and members of the committee. My name is Andrea Cowan Molyneux. I am the owner and principal designer of ACM Designs Incorporated, located in Halliburton, Ontario. I am the agent on record for the property owner, and while we do share the same last name, we have no familial relationship. This is my first time here, so I apologize, a little nervous. I will say that the client or the property owner and ACM Designs have worked since the summer with the planning department to come up with a suitable solution so that we could move the project forward in the best interest of the property owner's desire. We have met every request, and the spirit of the application is to work with the committee and comply with any constraints or outlined requirements that they may have, or the bylaw may, or the planning requirements may have. I would like the committee to know that we have, I would like to assert on behalf of the property owner that we did experience an undue hardship last month due to the postal strike. And we were actually on the agenda last month, but we couldn't comply within that time frame to provide Ms. Whalen with some of the requests that she had made, which has also delayed us being able to move the project forward. So I would ask that the committee consider that, and that was absolutely beyond the control of the property owner, us as the agent, and of course you as the committee. I would ask you to consider that when, if appropriate, the 20 days that I heard about in the previous application will be to required subsequent this hearing, that I would ask the committee to waive those 20 days if that is appropriate and within the purview of this committee's authority. I think that's kind of it. Not knowing what else to say. Apologize.
Are there any members of the public who would like to speak to this application? And we would start with anyone attending electronically. We've been connected with electronics.
I don't believe anyone's online.
All right. So is there anyone attending in person who wishes to speak to this application? No one here? Thank you. Are there any questions or comments from the committee to the application, the planners or any persons who have made presentations?
You, Madam Chair. I'm just curious, how long have the owners had this property to purchase the Shore Road allowance?
I'm not entirely sure. I know that it's in excess of 3 years.
Okay, so not a long time. 'Cause
No.
quite often people, apply to purchase their Shore Road allowance before having to, and it certainly is making a vast difference in the size of the property.
Yes, absolutely.
Yeah, that's what I was gonna say. You're purchasing sure road allowance. So it'll make a huge difference in that in size.
And
It'll
it's,
also help the roadhouse out too. Cause now you can actually repair it and get permits to fix it if there's a problem in the future.
I agree. And the clients acknowledge that as
Yeah.
well.
Are there any further questions from the committee? Yes, please.
Question for the planner, I guess. What happens if the SRA purchase cannot be finalized? For whatever reason, could be beyond control of the landowners or whatever.
I would, there are conditions, and right now, the process of the SRA purchase is ongoing. It is being processed. At this time, there does not seem to be anticipated issues. If the SRA purchase is not completed and transferred on title, then that would mean that the minor variance would lapse and would not be, no longer be valid. I'm not sure if Amanda. has
So
anything
would
to
that
add
mean
to
that they would have to take the garage down?
Possibly, there could be options. They would need to seek additional approvals prior, and that would be something to collaborate and converse with the building department as well as the conditional permit.
Or I guess they could come back.
You'd have to restart all over.
Yeah, come back to us, I guess. Okay.
Sorry, if I can just for a second take off my secretary treasurer hat and put on my manager planning hat. We only progressed down this path of this with this approach because we're confident that the Shore Road allowance can proceed. But again, as our planner, Ms. Whalen, noted, they can take some time. So that's why we've proceeded with the minor variance, but also with the conditional permit so that they can get those things moving. But with staff's confidence, both in the building department and planning, that this will proceed the way we're all hoping that it will. If it didn't for some reason, then they would require alternative planning approvals in order to legalize that structure. But that's something we would work with them with if in the rare instance that became relevant, but we're not expecting that to happen.
I've surveyed for 35 years.
Jean, did you have a question?
Oh, no, just having been on council, I hadn't seen a Shore Road allowance rejected. The sale of one.
All right, thank you. As there are no further comments, would the Secretary Treasurer please read the proposed conditions for the minor variance?
Through you, Madam Chair, I certainly can. I did want to just provide for the agent that appreciating wanting the 20 days waived. Unfortunately, that's not within the purview of the committee. It is a legislative requirement under the Planning Act. So that's not something that we're able to change. It's provincially mandated. So unfortunately, that's not something that they're able to consider. Through you, Madam Chair. So the conditions that are in the report, that the approval of the minor variance should only relate to the proposed one-story garage, which again would comply with all other applicable law. that construction would proceed in accordance with both the site and building plans, as well as including the purchase of the shore road allowance. That an Ontario land surveyor shall confirm the setbacks to satisfaction of the township, and also that the owner shall submit any supporting documentation as required by the chief building official prior to final inspection. This is slightly different than our normal condition, as it does recognize that the property owners do currently have a conditional building permit. So we did change that a little bit. And then the last being that in the absence of completing all those conditions, that the application would be refused.
Are there questions or comments from the committee regarding these conditions? None? Hearing all the evidence before it, is the committee ready to make a decision? Would the Secretary Treasurer please read the resolution?
Through you, Madam Chair, happy to do so. I'd be grateful of reasoning from the committee to include in the decision, though.
It's a pretty basic garage and it seems very reasonable, to, a reasonable addition to that property.
I think also that because of where it's positioned and the trees around it, you don't really notice it as an addition to the property.
Further comments? Are we ready to take a vote? Yes. All those in favor?
When
Oh,
you're
sorry.
getting ahead of me. That's okay. We're on. Just give me 1 second to write these out, and then I'll read it out for you first, and then
Thank
you can vote.
Good.
Moved by Paul Riddle, seconded by John Agate, whereas the Committee of Adjustment considered the written and oral submissions relating to application PLMV 2025-093 Cowan made at the hearing. And whereas it is the opinion of the committee that the temporary relief granted maintains the general intent of the official plan and zoning bylaw, is appropriate and desirable for the area and is minor in nature, and more specifically for the following reasons: that the garage is a reasonable addition to the development on the property, and that the position and the position of the building within the trees will not be visibly noticeable. Apparently I needed to work on that one a little bit more. Now therefore it is the decision of the committee that application PLMV 2025-093 requesting relief from the requirements of bylaw 06-10 is amended to permit the following: from section 5.2 to permit 19.6% total lot coverage, whereas otherwise a maximum of 15% is permitted. From section 4.1.8 to permit a 6.8% accessory building and structure lot coverage, whereas otherwise a maximum of 5% is permitted. And from section 4.9.1 to permit development on an existing undersized lot where additional relief from the zoning bylaw is required, all to be approved, subject to the following conditions: that approval of the minor variance shall only relate to the proposed one-story garage having a ground floor area of 51.99 square meters, 559.6 square feet, construction of which shall comply with all other applicable law. That development of the subject land shall proceed substantially in accordance with the site and building plan submitted to the township on October 20th, 2025, and put before the committee on November 24th, 2025, and forming part of this decision, inclusive of the purchase of the municipally owned Shore Road allowance as per application PL SRA 2025-101. That an Ontario land surveyor shall confirm the setbacks in accordance with approved site plan to the satisfaction of the township. That the owner shall submit any supporting documentation as required by the chief building official prior to final inspection to satisfy the conditional building permit as it relates to minor minor variance application PLMV 2025-093 and SRA purchase PLSRA 2025-101, and that failing any part of the foregoing conditions, this application shall deem to be refused.
So shall we now take a vote?
Yes, now you can vote.
All those in favor, supported? Thank you very much. It is carried. Would the Secretary Treasurer please advise the applicant and the public of the next steps?
Yes, through you, Madam Chair, having approved application PLMV 2025-093, notice of the decision will be sent out within 10 days of signing and identifying the 20-day appeal period. To be kept advised of an Ontario Land Tribunal hearing in the event of an appeal, members of the public must request a copy of the committee's decision on the application. Anyone from the public who would like to receive a copy are asked to contact the planning department.
So I now declare the matter to be concluded. Good luck. Good luck. Is there any new business to discuss?
Yes, through you, Madam Chair. So the committee is being asked to approve the schedule for 2026. So there is a meeting calendar that was included with your packages. The schedule for next year is proposed much the same as usual. It would be the last Monday of every month. There are 3 exceptions. The first is in June, just because the last day or last Monday of the month falls just before Canada Day. So we did want to respect the holiday as well. The meeting in October would fall on what would be the 2026 municipal election date. So those 2 meeting dates have been, both for June and October, have been moved to the week prior. And then for December, again, it's earlier in the month. It aligns with the same week that typically the council meeting for December would occur. And again, just respecting the holiday season as well. Yeah, that would be the proposed schedule for 2026.
So there is an election in October. This committee of adjustments carries on until, so you don't expect that there'll be a new committee before because new councils have new committees, so you don't expect that it's going to happen before December.
Through you, Madam Chair. So yes, what Committee Member Neville is speaking to is once there's a new council in place, they do need to reappoint the committee. The Committee of Adjustment would only be in place as long as the current council is in their positions. So we've left the schedule the way that it is, where we include a November and December, just because we're not sure exactly in terms of timing. If there's a lot of applications, there might be a rush to have the new council appoint members. So we did leave them in there. Otherwise, yes, those would be canceled, but we would announce those once we get to the closer to the October date.
When is the next meeting?
Sorry, are there any other concerns? I apologize, there is a resolution to approve the calendar if everyone's okay with the way that it is. Okay. So moved by, oh, sorry. Wait, okay, or do you have questions?
No.
Okay,
thank you.
sorry. Moved by Paul Rodolph and seconded by Jean Neville. Be it resolved that the Committee of Adjustment hereby approves the meeting calendar for 2026.
Thank you.
Okay.
So when is, oh, I'm sorry. Jean?
No,
Oh, my spot.
Yes, sorry, that's, yes, so it's carried. Okay, so sorry to answer your question, Madam Chair. The next meeting will not be until January 26th.
Would the Secretary Treasurer please read the resolution to adjourn?
Moved by Jean Neville, seconded by John Agate. Be it resolved that the Committee of Adjustment meeting be adjourned at 10:25 a.m. on November 24th, 2025. The committee will reconvene on January 26th, 2026.
That is carried. Thank you.